Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and this morning I'm looking at a book which has come to us from Maxwell, Thomson, Reuters, and it's called Duress, Undue Influence and Unconscionable Dealing. It's now in a third edition and it's been written by Nelson Enonchong. We've given for our review title the following, quote, "The weapon with which the common law protects the victim of improper pressure." And that's what the book basically is about. We obviously within the legal profession used to refer to them as vitiating factors, but we're trying to make it a bit more modern today. Let's have a look at the book anyway. First of all, there's the front page, or front of it. There's the side. You can see it's the common law library. There's nothing on the back. It's a hardback and it's a very dark green cover. The index is by paragraph numbering, so you can see the structure. Very much really the house style of Thomson, Reuters, and Maxwell. And at the beginning it talks about the legal taxonomy, which explains how the indexing actually works. It's very much a structure that have created themselves. You can see the last page, paragraph numbering at the sides and footnotes at the bottom. The front of the book, there's the front page there. Then you've got after that some blurb about the book, then a preface, which is always worth reading from the actual author. Then you've got a short contents section of the various chapters and parts. There are in fact a total of 5 parts, 29 chapters. Then you've got a detailed set of contents which tries to set out what you may well be looking for, because this is very much a complementary text to go with chitty on contracts. Table of cases there, a lot of case law of course in this area, and as I've said it can be confusion of course to undergraduates sometimes because the cases can be quite confusing. Tables of statutes, I think again the author explains that well. Table of statutory instruments. Then non-UK statutory material. There'll be quite a lot of that, notwithstanding whatever happens to Brexit. Then you see the structure of the book. There's a mini index at the beginning. Then you've got the paragraph numbering at the sides, and then footnoting, and that's the way it runs all the way through. Some of the little indexes a bit bigger than others. There's the book anyway. It runs to something approaching just under 600 pages in total, but about 600 with the cases and various other bits and pieces that are in it. Right, so what do we say about the book? Well, this. We say check out the new edition of this classic text on a key subject, because obviously the law of contract is a particularly important area. So, quote, "Duress, undue influence and unconscionable dealing, what a horrible and unholy trinity of wrongs, redolent of guile, bile and malice aforethought." Thank goodness then for this highly regarded legal text, now in the third edition, from author Nelson Enonchong and the publisher Maxwell, Thomson, Reuters. Lawyers across the spectrum, we feel, within the legal specialities, not to mention academics and students, will certainly welcome it. And while the subject matter is dealt with, as I've indicated earlier, in Chitty on Contracts, this book offers more of a specialised and detailed approach, covering as it does virtually every aspect of this often rather opaque area of law, hence the fact it's part of the contract law library. Whether relative novices or seasoned specialists, practitioners finding themselves involved in, as is often the case, contractual issues and sometimes of course family matters, in which duress looms large, will find this book especially useful for the considered and ever reliable advice that it provides. And as the author points out, there have been significant developments in the law relating to these areas, duress, undue influence and unconscionable dealing, since the publication of the previous edition, as exemplified in a number of recent cases. And there's much discussion and clear explanation of how, when and why these three areas overlap. The book therefore focuses on the circumstances that arise when an otherwise valid transaction may be avoided on the grounds of any one of these areas or all three. And we use, of course, the term voidable. Again, that's something that may not be familiar to some people, but that's the terminology. I know we're moving away from some of this, but that's the terminology that's used. And, of course, more importantly, the book makes clear that duress is the weapon with which the common law protects the victim of improper pressure. It is indeed among the vitiating factors long recognised by the common law, where the consent of the complainant has been procured by illegitimate pressure. There is therefore much discussion of remedies, which is right, of course, as usual, at the back of the work, including, of course, rescission. Historically, says the author, the law of rescission on the ground of vitiating factors developed along the jurisdictional divide of common law and equity, and is unequivocally defined as the principal remedy for duress, undue influence, or unconscionable dealing. And of course we will all remember the conflict between common law and equity prevails. Of course, again, the important point about rescission is the discretionary element, and that of course is always the hallmark of equity. Primarily then the book concerns itself with English law, but with an underlying comparative approach nonetheless, which I found helpful. There are numerous and useful references to other common law jurisdictions. That includes Australia, Canada and Scotland. I know that's not common law, but it's part of it, all of which in the author's opinion may assist with an understanding of the principles and concepts of English law. I mean, Scots law obviously does have an overlap, but again that is included. So let me conclude by saying this, that as it does much to provide clarification of a complex subject, this work of reference should be regarded by practitioners as well nigh indispensable, especially as it's carefully structured and therefore relatively easy to use. Note the detailed 25-page table of contents, for instance. That's the simple bit at the beginning, the very short one, then the much more detailed area, which will give you all the subheadings so that you should find what you want. Then, of course, there's an extensive index with the legal taxonomy at the back. And paragraphs are numbered throughout, which is easy and helpful. There's a lengthy table of cases, plus, of course, the usual tables of statutes, SIs, and non-UK statutory work materials. And as I've said before, that will include and continue to include EU stuff. It's fair to say, then, that this new edition is an essential tool for lawyers, as its subject matter is relevant and applicable across so many areas of law. And the date of publication is cited as at early 2019, but it may appear sort of at the turn of the year 2018 in some links. Let's just have one last look at the book again. There's the front. You can probably actually not see it that well. And there's the side. Let's just open it in the middle. It's a heavy book, and I'm very impressed with it. There's a lot of detail. For instance, let me give you an example here. This is on relationships in which the presumption of influence applies. You've got a paragraph number there. You've got the relatively short number of footnotes, not too much. But what you've got is you've got the judgment and then a reason. In this case, it was Mr. Justice Dixon's reasons, which are looked at again by the Supreme Court. And I think that's the case. In fact, no, it isn't. I think that may well be the House of Lords. I'm not quite sure. Let's have a look. Yes, it's actually the House of Lords at that time. The point being that you're getting a very reasoned set of arguments which should assist you depending on what type of case you've got. And just going ahead, a two-stage approach on undue influence again. So it's very, very thoughtful work. Thank you very much to Nelson Enonchong. I'm very grateful to him and to everybody who's been involved in the production of this book, and of course all the other works in the Common Law Library. Thank you very much to all. Bye-bye.